Welcome to the deep dive. We take complex sources, articles, legal documents, history, and we really try to boil it down for you, give you what you absolutely need to know.
Get you up to speed quickly.
Exactly. And today, we're diving into Eritrean sovereignty, specifically looking at arguments around it, Ethiopia's historical sea access claims, and this source's very particular view on historical justice.
It's quite a focused perspective we're looking at today.
It really is. This document, well, it doesn't pull punches. It's offering a very firm, specific legal and historical viewpoint. Not much room for ambiguity.
No, not at all.
So our mission, for you listening, is to distill that core legal argument for Eritrea's sovereignty as this source presents it, and how it pushes back, quite strongly, against certain historical claims. We're aiming for clarity here.
And that clarity starts with really the foundational idea in this document. It states that respecting sovereignty Eritrea's, like any nation's, isn't, optional. It's not a favor.
Right.
The source just lays it out. It's international law, period. That's the bedrock. Everything else builds on that assertion.
Okay, international law, period. So let's unpack that. The source argues this sovereignty is unconditional, right? Not up for negotiation.
Absolutely. Unconditional. Non-negotiable. It's not presented as something temporary or, a bargaining chip for later.
So what makes the source so sure? What locks it in, legally speaking?
It really zeroes in on the independence process itself.
Yeah.
Specifically, the referendum. The source places huge importance on its legitimacy.
The UN-monitored one.
Exactly. That's key. UN monitored, and the source stresses it showed the clear aspirations of the Eritrean people.
Okay.
And in international law, an act of self-determination like that, overseen by the UN, that's generally seen as definitive. Very hard to undo.
So it's not just a political statement. It's a legal event with consequences.
Precisely. And the source uses this interesting phrase. It says the referendum result was not a draft memo.
Not a draft memo. I like that. It's final. Sealed.
That's the message. It's done. You can't, as the source puts it, just decide to look at it again every time nostalgia strikes.
Which implies that some people are trying to look at it again, driven by nostalgia.
Well, that's the implication, yes. The source insists the borders, the legal separation, they're fixed by that internationally recognized process.
So if you accept the UN process,
then you have to accept the outcome. Eritrea's sovereign independence is settled, and crucially, its right to exist doesn't, legally speaking, hinge on whether Ethiopia gets a port.
they're separate issues in law.
According to this source, yes. One is a fundamental right of statehood. The other is a neighbor's, perhaps understandable but separate, desire for access.
That distinction is vital. But, politically, that feeling of loss regarding sea access constantly comes up for Ethiopia. Which brings us to the next big point.
Right, the narrative of injustice.
Exactly. The idea that Ethiopia was somehow wronged historically by losing its coastline. How does this source tackle that?
Head on. It shifts the focus entirely. Instead of talking about the loss, it forces you to look at the origin of that sea access.
How Ethiopia got access in the first place.
Precisely. And this is where the source makes its key move. It argues that access wasn't some ancient right that was taken away.
Okay.
It argues that access was gained through an illegal annexation.
Ah, so connecting it to the Federation and annexation period.
Yes. By framing the origin as illegal, the source completely reframes the ending of that situation.
So if the original act was unlawful,
then reversing it can't logically be an injustice. It can't be a wound. That's the argument.
that completely flips the common narrative. It's not a loss, it's presented as a correction.
A legal correction, yes. The source uses strong language here. It says reversing the annexation wasn't a wound in need of healing, definitely not a demotion for Ethiopia.
What was it then, in their view?
It was justice being restored, plain and simple. The underlying idea seems to be, rights can't spring from an illegal act.
Right, like you can't claim damages because someone took back something you stole.
That's a good analogy for the source's logic, yes.
Yeah.
You can't claim injustice when you lose something you never legally possessed.
So Eritrea gaining independence wasn't creating an injustice.
It was, in the source's view, correcting one, the original annexation.
Okay. That's a powerful reframing.
And the source doesn't let you forget the cost of that correction either. It emphasizes the human element.
How so?
It explicitly mentions the sacrifice, the lives, limbs, and the sacrifice of Eritrea's best sons and daughters.
So grounding the legal argument in lived reality and struggle.
Exactly. It adds this layer that says this wasn't just a line drawn on a map in some office. This legal status was achieved through immense struggle, making any attempt to renegotiate it seem, well, disrespectful of that sacrifice, on top of being legally questionable.
That adds significant weight. Okay, so we have this firm legal stance rooted in the referendum and the critique of annexation, underscored by sacrifice.
Yet the discussion continues.
Right, and people try to sort of have it both ways.
Yeah.
Which leads to the third core point in the source, this critique of contradiction and maybe revisionism.
Yeah, the source seems quite impatient with that, with attempts to hold opposing ideas at the same time.
What's the specific example they give?
It points to a common kind of statement you hear. Someone says, oh, we absolutely respect Eritrea's sovereignty, BUT.
Right.
But then they immediately start to, and I'm quoting here, mourn a coastline Ethiopia never legally owned.
So affirming the legal reality and then immediately lamenting the direct consequence of that reality.
Exactly. And the source is blunt about this. It calls it not analysis, but just plain contradiction.
You can't have the legal outcome without the physical, geographical outcome that comes with it.
That's the source's position. They have to align. You can't logically separate them.
So the source sees these fixed historical facts, sovereignty, confirmed by referendum, annexation deemed illegal. He says these are not negotiable in a policy paper.
Right. They're presented as closed issues, legally speaking.
So why, then, does the source think people keep trying to negotiate them or debate them?
This is where it gets into diagnosing the problem. It suggests that trying to turn these settled facts into ongoing debate topics is just intellectual gymnastics, meaning contorting logic, playing with words, maybe to avoid confronting the established legal and historical reality. Obfuscation, perhaps.
And does it identify why people would do that? What's driving these gymnastics?
It does. It points to three specific root causes as it sees them.
Okay, what are they?
First, imperial nostalgia. A longing for a previous era, a larger state, that kind of thing.
Right, looking backwards.
Second, historical fairy tales. Simplified, often nationalistic, but factually inaccurate stories about the past.
Okay, nostalgia, inaccurate history. And the third?
And third, simply bad education. A failure, perhaps, in education systems to teach the clear historical and legal record accurately.
So it's arguing that emotion, flawed narratives, or lack of knowledge are clouding judgment, overriding the legal facts.
That's pretty much it. That commentary and sometimes even policy thinking are being driven by these factors rather than by adherence to international law and documented history.
And the source sees danger in that.
Oh, absolutely. It doesn't see this as just, harmless academic debate or political spin. The conclusion is quite stark.
Which is?
That these distortions, this allowing of nostalgia or fairy tales to override law, especially if leaders buy into it, it warns this can ultimately cost lives.
Wow. So it connects flawed historical interpretation directly to potentially devastating real-world consequences.
Yes. It puts a heavy responsibility on commentators, on policymakers to stick to the facts, stick to the law, even when it's uncomfortable or goes against a popular narrative.
Absolutely. Okay, so wrapping this up for you, the listener, what's the core takeaway nugget from this particular deep dive?
Yeah, what should you hold on to?
Well, this source presents a really stark conflict.
Yeah.
On one side, you have this deeply felt sense of historical grievance, maybe nostalgia, that persistent focus on the lost coastline.
That emotional historical pull.
And on the other side, you have what the source presents as the unshakable finality of international law and historical fact. Specifically, the source's interpretation of the annexation as illegal and the UN-monitored referendum as the definitive correction. It's really that clash.
Law versus longing, almost. And the source comes down hard on the side of law. It makes a powerful case, you have to say, for legal finality and what it calls the restoration of justice.
Definitely a strong perspective.
So, building on that, here's a final thought for you to consider, based purely on this material we've examined. If these historical fairy tales and this powerful nostalgia can, as the source warns, override established international law, and if that distortion truly has the potential to cost lives, then what does that imply about the international community's ability, or maybe responsibility, to insist on factual and legal clarity, especially when facing down powerful national narratives that might be based on those fairy tales? It really makes you think about where the line is drawn between respecting national identity and upholding international legal obligations.